Hi, my name is Nina, and I'm talking in behalf of Audit Radley. I want to talk about today the hearing procedure of in Israel, according to the rulings of the labor court and according, to the law. I'm actually reading out from I did a translation from a site called Kol Zchut, which is a very handy site which summarizes your rights in Israel. Okay, so I'm reading out loud. According to the rulings of the labor courts, an employer is obligated to hold a hearing for the employee before dismissal, in which the employee will be presented with full reasons for the employer's desire to fire him, and the employee will be given an opportunity to make arguments in favor of continuing his employment. Okay, the employer must give the employee a written summons for a hearing, a reasonable time before proceeding, and specify in the summons the allegation against the employee. The employee may invite a representative on his behalf. It can be an attorney, employee committee representative, a family member, etc., to the hearing. The employer must document the hearing conversation using a protocol, include in the minutes of the employer response to the employee's claims. I actually, since I'm a tax advisor and I can automatically be a salary controller, I mean, it is used that the employees come in and do the recording also. They want, a documentation regarding the procedure. So there's a main element in the hearing, a very pronounced element, which is also it's a concept that is very central in the employer-employee relationship, and that is the duty of good faith. The duty of good faith is actually a legal concept that originates from the contract law, but it's much more used. It's the principle that the relationship has to be honest and fair towards the person of the other side of the barricade. The duty of good faith is also an inherent part of the employment, as I said, employment relationship, which after all are kind of a contract between employer and employee. The application of the duty of good faith in labor law was determined by the labor law courts, which continued to develop to this day in its ruling. So the labor court said that in employment relationship, it has to be an increased duty, as I said, duty of good faith, an increased duty. That is a higher requirement of morality than of the ordinary duty of good faith. I mean, if you are going to a shop and you're buying and selling, I mean, you don't have this, relationship, the duration and the inherent power gaps that you have to, you as an employee have to, show and respect your employer. So in that case, the employer has to show a higher morality or a higher duty of good faith. So as I said before, the dismissal procedure is a process where the employee is really, at the bottom. So the duty of good faith has to be, even more increased. The entire dismissal process is subject to increased duty of good faith. But the hearing process is in particular. In order to exercise the employee's right to plead, the hearing must be honest and truthful. That is, at a time when no decision has yet been made on the employee case. Okay, so in order to emphasize the importance of a lawful hearing, the ruling states that even such dismissal would be considered dismissal in bad faith. So, I mean, as was mentioned in in the beginning, from the side of a Kolsrut, you have to give uh, enough time for the employee to be prepared. You have to, show your evidence as well. What the hell are you talking about? I mean, not give a general letter, but even, give a proof. And okay, I mean, I'm not a lawyer. I'm not a labor lawyer or anything. Okay, I'm just I can be a salary controller, and I need to, as a salary controller in Israel, you need to advise in some cases where there's no way human resources, or there's a problem with you have to refresh their minds to the procedure of your partner who's in charge of the department, or anything like that. So that is very important. But I mean, an employee who is going through a process like that, and can go to the labor court and can sue the employer, which is it's not a nice case for employer to do. I mean, if ever you want to have it's not a nice case to have any law cases against you with this kind of bad procedures going on. I mean, anyone can look at the court cases, and if a company, has to show to the directors at the end of the year, and it's not neither for a corporate, neither for I mean, I don't know. Anyway, that's it. You're exposed to risks as an employer, and also it's a not ECSG. I mean, if you have to be in good faith, and also know the law, because I mean, you might think, oh, I'm a very good boss because I gave him candy. I mean, like running a family. He wanted candy, I gave him candy. No, you have laws in Israel, you have procedures, which that's your guidance. And I mean, that's your good faith. If you're giving it in, I mean, if you're firing a person every 3 months, a person every 3 months, because every 3 months, or every 6 months, it depends on which you're enforcing, which pension procedure you're enforcing. But if you have a habit like that, and the employees understand it, you get fired. I mean, some people in tourism see that happening, and they ganged up, and they said, well, look, we're going to sue you because you what is known as a seasonal employee, and you can't really do that. Okay, so that's the summary. Have a nice day, and you're welcome to press like and be updated in the site.